Hi. So today I am going to share with you the technique of winning a specific performance suit, how to obtain a decree in a specific performance suit. Now, what is a specific performance suit? It is in general terms, specific performance suit is a suit that is filed, it's a court case that is filed by the buyer against the seller who fails to come to the sub-registrar's office for the registration of the immovable property sold to the buyer after entering the agreement of sale, unregistered agreement of sale or registered agreement of sale also. But generally what happens is only in an unregistered agreement of sale, seller after taking advance doesn't come to court. So invariably specific performance suit is filed to perform the agreement. Now, what are the conditions where you can obtain a decree in a specific performance suit is what I am going to share with you today. Now, to obtain a decree, you must understand the difference between what is an oral agreement of sale of an immovable property, what is a written agreement of sale of an immovable property, what is an oral agreement reduced to writing. So these three kinds of agreements are there. Another agreement will be the registered agreement of sale. So I will explain the difference between each and every kind of agreement. Oral agreement doesn't have any written document between the two parties. Written agreement of sale will be of two types, which will be registered or unregistered. And oral agreement of sale reduced to writing will also be in a form of a document. Now, if you inform the court that you entered an oral agreement of sale, there is every chance you will get a decree. If you inform the court that you entered an oral agreement of sale which was reduced to writing, then also you will get a decree against the seller. That is, court will direct the seller to come and register the property to the buyer, and if he fails to come, court will come and register. That is to say, judge will come and register the property in the place of the seller. And if it is a registered agreement of sale, by paying the stamp duty, whatever may be in your state, because it varies from state to state, then also you will get a decree of agreement suit for specific performance, in a suit for specific performance. But when you enter an unregistered agreement of sale, now this is the core point in this entire video. When you enter an unregistered agreement of sale, which is 99.99% of all the real estate transactions in our country are entered through unregistered agreement of sale, then if you don't carefully handle the case, your suit will be dismissed. Because what is the law pertaining to the unregistered agreement of sale? The law is very clear. Unregistered agreement of sale is an illegal document in the eye of the law. When it is an illegal document in the eye of the law, it will not be marked as evidence. Illegal material objects are confiscated by the courts. They will never be led as evidence. They will never be supporting material for evidence. So unregistered agreement of sale without paying stamp duty is an illegal document before the judge. So judge has every power to confiscate the document and send it to district collector and collect the stamp duty. For collecting the stamp duty, as per the Stamp Act, the penalty is 10 times. So up to 10 times penalty can be collected. Now, how to use this document as an evidence is what I am going to share with you. Now, every contract between two parties. Now, what is a contract between two parties? It is an legally enforceable agreement is a contract. Now, any agreement between two parties which is enforceable with the aid of law is a contract. That is the definition, basic definition of a contract. Now, every agreement of sale whether it is oral agreement of sale, whether it is oral agreement reduced to writing, whether it is a registered agreement of sale, or whether it is an unregistered agreement of sale, they all are contracts. But unregistered agreement of sale is not a contract, because it is an illegal document. It cannot be enforced by the court, because as I had said earlier, the definition of a contract is a legally enforceable agreement is a contract. Now the point here is, what I am trying to say is how to legally enforce that unregistered agreement of sale is the topic of this video. Even an unregistered agreement of sale has also some legality, which is the point which I am going to share. I will once again repeat, an unregistered agreement of sale has also some legality. That legality will be allowed by the court. Now, unregistered agreement of sale will have two parts. One is the legal part, that is to say, the contract between two parties, that is the buyer and the seller, the payment of money, the acknowledgement for the payment of money, and the illegal part is not paying stamp duty. Now, when you go to court, you have to enforce it as a contract for specific performance suit, not as an agreement of sale for specific performance suit. Try to understand. You have to enforce it as a contract, not as an agreement of sale. There's a subtle difference. That is to say, you have to convince the court, that is the buyer has to convince the court that there is a contract existing between the two parties. Undoubtedly, it can be used for the refund of your advance sale consideration, which is the collateral purpose. Now, that agreement of sale can be used as a collateral purpose. That agreement of sale can be used as an evidence of a contract between two parties, but it cannot be used as an agreement of sale because there is no stamp duty on it. Hope you understand. So you have to insist the court that there is a contract between two parties, there is an oral agreement, it is a deemed oral agreement reduced to writing. So you have to convince the court that it is a contract, so mark it as an evidence. It is a contract, so mark it for refund of sale consideration for a collateral purpose. So if you remember this point, if you ask the court to enforce it for a legal part, court anyhow knows it, but if the seller takes a defense that it should not be marked, then you have to say that you are requesting the court only to mark it as a contract between two parties. Through that admission, now when if that admission is taken by the buyer against the seller can't deny it. Seller can deny only the illegal part. The legal part seller cannot deny because seller anyhow accepts the legal part. That is the contract between two parties. When seller admits the contract between two parties, that document will be marked as evidence. When seller denies the contract, listen carefully, if seller denies the contract, that is to say, if he starts taking a defense that he never signed the document and it is not his document, there is no contract between the two parties, then that document will not be marked. Then if it is marked also, it will not be considered as an evidence in favor of the buyer. Hope I am clear. This is a slightly tricky situation. There is a subtle difference between treating it as a contract and treating it as an agreement of sale. You have to carefully listen slowly so that you will understand. I hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.